Excellent, excellent. So we'll start with the Honorable Michael Kanan, who is going to talk about a couple of the rules for us related to family rules.
Well, just for a historical note, I will note that when I was in your role, I had to proceed without quorum, particularly during the session, when trying to get enough, getting more than 5 members together was sort of like herding cats. So
I appreciate that.
It happened for years. Well, fortunately, I'm not reporting on anything which is controversial, so I don't know that I will cause any problems for you. I'm reporting for family rules. There are 2 items on your agenda from us, and that relates to Rule 18D2. And this is sort of a one of those things that has gotten added post-COVID. So pre-COVID, there was a strong preference to have mediations take place in person. And if you read the rule, it says the parties are expected to attend all mediation sessions and mediate in good faith, and attended was presumed to be live. And in COVID, mediation took place by video or some other type of virtual proceeding like we are today. And that was by necessity because you couldn't put a bunch of people in a room. There was, I believe it was really from the bar, some sense that if all the parties and the mediator agreed, there should be the option of holding the mediation virtually and not having to go to the court and file a motion to do it that way. So the change now, the underlying provision on it says parties may participate in mediation using remote technology at the discretion of the mediator or by order of the court. So that's, you can ask, the parties ask the mediator, are you okay doing it virtually? Mediator says yes. It doesn't have to be, nobody has to motion the court. I think that's uncontroversial.
Yep, that's fairly straightforward. Any questions? No. I think we're all set with that one. No, that looks good. Thank you.
You're welcome. Then it looks like there are a lot of rules here, 2A, 3, 6, 2, 6C2, 61C1, and 8H. But it's fairly straightforward. Rule 78A was taken out by the Civil Rules Committee. And what happens is most of the family rules relate to civil rules. So in our Rule 2, Family Rule 2, we say the following civil rules apply. Well, when the Civil Rules Committee changes a civil rule, then we have to modify Rule 2 to reflect the change in the civil rules. The Civil Rules Committee eliminated demurrers, and I hadn't seen that. It's an old common law pleading. I don't think I ever saw it used, and certainly never saw it used in family, but that's not there anymore. And with respect to motions procedure, that used to be contained in Rule 78, but now that's in Rule 7. So what we did was took the phraseology from Rule 78B, and it's now located in 7B4. Doesn't change anything substantively, it's just where the rule is located. And so that reference is changed in several rules. In terms of Rule 6, that's guardians. Again, we changed 78B to 7B6. Perhaps a little more, and then that's true also in Rule 8, called magistrates proceedings. Then there's a lot of cross off in the changes to Rule 6A and 6.1A. And those are the rules regarding representation by attorneys and guardians with respect to minors. It looks like there are a lot of cross-offs, but the cross-offs all relate to probate provisions. The probate rules used to relate to the family rules when it came to appointment of guardians and attorneys. Shall I pause while the Honorable Senator Clarkson sits?
How are you? It's so good to see you. Maxine is here. Oh my God, all my favorite people. Where are you, Kanan?
In Brattleboro.
I just left a meeting with Julie, or I'd have been here earlier.
A fine excuse.
I never got that package, so I have no idea even what we're talking about.
Would you like us to wear our masks? What do you-
Well, after Tiff, are we live?
We are.
Oh,
That's
You
fine.
are.
And I know there is a member who tested positive. I'm happy to wear my mask.
yeah, we just, that's why I've been pretty good, and I hope I was with the member who got it yesterday, because I kind of.
Yeah, yeah. Okay, sorry. Sorry, Your Honor, for,
Quite all right.
yeah.
Well, it's good to see you, sir, and I apologize for being late. Where is our committee?
Here, and we have Tom Burden online, and Senator Sears may be showing up, but a little bit late, he said.
Well, I sadly, okay, I never got any of that, so.
Oh, it should be
you
on
print it
the
all
line.
out?
Yeah, I just printed it out.
Oh, okay, well,
I sent it to Tony.
okay, I dropped my computer on the way over here, which is part of why I'm late. Ooh, thank you, what's this? That's what we're dealing with? Okay,
Yeah.
great. Thank you, sorry to be so,
Oh,
Well, we're happy
Disruptive.
that you made it.
I'm so happy to be here. Okay. So, where were you guys?
We're on the second rule.
Okay.
all right. So I was just going over Rule 6 and the change to Rule 6 with respect to representation of attorneys and guardians ad litem of minors. The probate rules used to refer to the family rules for the appointment of attorneys and guardians. The Probate Rules Committee put together its own rules for probate cases for the procedure and the circumstances under which guardians and attorneys are appointed. And so the probate courts no longer use our rules for attorneys and guardians. And so the strikeouts in Family Rule 6 relate to excising reference to probate court proceedings where they might be appointed. So that's the change on Rule 6. And that's unfortunately the end of my report, Senator Clarkson.
You know, save the best for last. Anything about guardian ad litems is good. I hope it's all improved.
So I don't know if you have any questions, but
Any questions? I think we're good.
okay.
At least we're accepting. I'm not sure.
All right. Well, I thank you all, and I hope you have a good day, and perhaps somebody else has something more interesting or controversial.
Thank you for your work on these. It's great when you guys put in all the work into these rule updates.
So,
Yeah, good to see you.
all right. Good to see you. Have a good evening.
Yeah.
Thank you. Thank you
Yeah,
very much.
take care.
Bye.
Very much.
So I hate to say this, but
So I think where you would find it is email from Mike.
because there's nothing here on our website.
Yeah.
It says week of Monday, March 28th.
Yep.
So I go to other documents?
Nope, go up. Click on, nope, not joint rules.
So I think we have
Oh, right.
Judge Treadwell is
Joint
next. Am I
rules or
correct on
something
Joint
that?
committees.
That's it. That's where it went.
That's okay.
I am
Looks like,
here, Representative, but I have Judge Morris here as well.
Oh, okay. All right. Whoever wants to go
Click on
first, that is absolutely fine.
Click on that.
We're on
Click
Yes.
that.
the Rule
That'll get you
7,
the
I
hyperlinks
believe,
to everything.
Thank
if I'm not mistaken.
Sure. So I can go ahead and then our Chair Judge Treadwell will intervene, I'm sure, to supplement anything I might say that comes to his mind. So in this segment, which we're talking about criminal rules proposed and promulgated, We've got two on the agenda, really three. I'll bring you up to date on that third one before I'm done here. But Rule 7, the committee will recall meeting and discussing this one at the June meeting, June 16th. Rule 7 deals with amendment of a indictment or information. And this rule dates from the original promulgation of our criminal rules of criminal procedure back in '72. This amendment, as you'll recall, adds a provision for amendments of charging documents by the prosecuting attorney before trial. The rule has always addressed the standards for amendment during a trial. And as you might imagine, the basic principle here is that any amendment that occurs under the existing rule during trial must not result in prejudice to the defendant in terms of notice of the accusation against them or the opportunity to prepare to respond to that particular charge. So if during a trial, a prosecuting attorney were to amend a petty larceny case to a sexual assault matter, well, obviously that would be so askance from the noticed charge that it would warrant a continuance of the proceeding at the least. So this amendment adds a provision for amendment of a charging document in the late stages of a case. In other words, when it's on the eve of jury selection and proceeding to trial, when the court in most serious cases has already blocked off days for jury selection and trial of that particular case. And a failure to proceed on that schedule will result in certainly delay in the proceeding. And the contrary would be that if one is forced to proceed to trial on a substantially changed charging document, that would result in prejudice. So this amendment basically sets standards for the court's consideration of these late stages amendments. It brings forward existing law regarding how prejudice is calculated in the given case and what might not be prejudice. Merely a ministerial change of the wording of a document without really changing the substance of the charge is generally not considered prejudicial at all. And the juncture at which an amendment takes place is weighed in. So if 2 weeks after the arraignment of a charge, the state's filing a more serious charge, say it ups it to a felony from a misdemeanor, well, you're early in the case. And so the prejudice would not result in any court action or intervention as to that charge. If it's on the gates of trial and we have a significantly different offense charged or additional charges dropped into the bucket or an enhanced charge where one was not previously brought, this rule gives the court the authority to, as the rule says, strike that amendment and have the option of the state proceeding to trial on the existing charge. Again, the test is whether prejudice will result to the defendant as a result of the late stage amendment. It has been a problem in certain of our courts where, despite due diligence, the prosecuting attorney comes into new evidence or the case is seen in a different light when it could not have been seen in that light before, which would justifiably warrant the amendment. But in any event, the test remains whether prejudice results to the defendant. The way the rule is structured, the amendment for pretrial amendments, a prosecutor can bring a charge, amend a charge, because that's clearly within the executive branch function of a prosecutor. The defense has the option to move to strike. So in other words, there needs to be a motion to strike brought forward. Essentially, it would allege that prejudice would result by going to trial. And the court has the option to strike the proposed amendment. Now you might ask, well, what's the consequence of that? As the decisions of our Supreme Court and as the reporter's notes to this amendment indicate, generally a presumption would be that if a amendment is stricken, it's without prejudice to renewal of that charge in another context. The bar would be, of course, if jeopardy attaches on essentially the same crime as has originally been charged as to the amendment. And if a defendant's acquitted there, then that would preclude another prosecution. The idea came forward from some of our trial judges who felt strongly that they ought to have authority to do something about late stage amendments rather than simply continue cases that have been long scheduled and set for many days of trial. So we did discuss this at the June LCJR meeting. There were no objections raised at that time. The court promulgated the amendment as final January 18th. Our Criminal Rules Committee met about 2 weeks later. There was very little experience time with respect to the implementation of the amendment. But of course, the committee was the proponent of the amendment, and that's where we stand on that. We did change the description in the caption, I should say. The existing rule says amendment of indictment or information. And you'll see from the document, we switched the order because it's rare to have a defendant charged by indictment in Vermont. We don't generally proceed by grand jury. It's the state's attorney's prerogative to make charges. So I don't know if Judge Treadwell wants to add to what I've said before we have questions.
I think we had a question first from us.
Walter, could I just ask you a question? Please?
Certainly. Absolutely.
I'd love to know who serves on criminal rules. Is it a whole range of those of you involved in the criminal judicial world?
Right. There's 12 members appointed by the court. There are state's attorney representatives. We have an attorney general designee. We have a defender general designation. And there's court clerk Lori Canty. Let's see. We have a victims advocate representative. And we have private practitioners. We have about 3 or 4 attorneys who have worked, frankly, sometimes some have worked both sides of the fence, prosecution and then defense now. So it's a blend.
Thank you. Yeah, I was sure it was, but I hadn't. Thanks.
And the number of judges.
No, oh, that's true. A number of judges. We
Oh,
have
of course,
3
John.
judges.
They maybe outweigh everybody else.
Yeah, we have Judge Treadwell, we have Allison Arms, Judge Allison Arms, Judge Marty Maley are serving on the committee. If you'd like to know, by the way, about who's on any of the advisory rules committees, go to the court's website. There's a block about the judiciary, and then there's a section, if you drill down, it's boards and committees. And you can find out who's a member of every single board or committee that the judiciary has.
Thank you.
Appreciate it. Any other questions on Rule 7? I don't see, and I see that Tom Burnett's not raising his hand. So thank you very much. This looks great. We'll move on to the next rule, to Rule 45.
Thank you. So Rule 45 is the criminal rules version of a rule that is held in common with civil rules and probate as well, and actually the appellate rules. You'll find later in your agenda, it's agenda item 12A, some of the things that Judge Keenan talked about earlier, and this Rule 45, these amendments are identical to what you'll also see brought forward on agenda item 12A, which is a cluster of civil rules amendments dealing with service and the computation of time. I don't want to steal civil's thunder, but Rule 5, as Judge Keenan has indicated, is the real workhorse procedural rule for many other divisions, even though it's vested in civil. Family rules defaults to Rule 5 regarding civil, regarding service and filing. Criminal rules defaults to Rule 5 by saying the civil rules shall govern the manner of filing and service in criminal proceedings. So this rule here, 45, has 2 changes proposed. One deals with the Supreme Court's interim adoption of a rule in AO 49 that authorizes filing by email addressed to the clerk of the court by essentially those who do not file under the Odyssey file and serve system. So that means all self-representers, unless they elect in, are going to be exempted from Odyssey e-filing. During the COVID period, the court authorized those folks to file by email. You know, we have our email accounts and we don't go into Odyssey during that period. The court directed the Civil Rules Committee, you'll hear this afternoon later, to promulgate a permanent rule or a standing rule that would allow non-e-filers, mostly self-representers, to file routinely by email into the courts. My take, a very good idea for those who are conversant in emailing, which a lot of folks are, and yet who are not obliged to, nor do they want to become involved in the Odyssey file and serve system. So the First Amendment to Criminal Rule 45 deals with a very small part of the rules regarding computation of time. It just says this: if you're filing by email, the time by which your filing is made is up to midnight of any given day, the same way that an electronic filing, e-filing under Odyssey File and Serve would be calculated. So in effect, it gives the email filer, I got to keep my words straight, the email filer has up to midnight to file their paperwork to comply with any time deadline. So that's all that change does. And you'll hear later about that in the context of the discussion of the Civil Rule 5 amendments. The Civil Rule 5 amendments. So again, what we're talking about here are rules that simply relate to, in some way, the later Rule 5, Civil Rule 5 amendments you're going to hear about, a bigger package. The other section that's amended here is Rule 45E. You'll see that little remaining section right there. We have had in the rules for computation of time, civil, criminal, family, appellate, a provision that allowed an additional 3 days for computation of the time allowed where certain responsive pleadings had to be made. In other words, if a motion was made by one party and a response was due in 10 or 14 days, in the old world before electronic filing, an additional 3 days was automatically considered tacked on to the compliance date. We're now proposing, and you'll see this in the civil amendment as well, and as by default, the family as well, that the 3-day period be eliminated or abrogated as unnecessary in view of the movement to electronic filing. I mean, right now, e-filers are getting up to midnight to make their filings. And so the view of the committees was that this 3-day add-on was not necessary in view of the movement to electronic filing. The Criminal Rules Committee supports it and sees no problem with its implementation of this abrogation of 3 days. And my understanding is the other rules committees, as they've examined the rules and abrogation of the 3-day period, feel the same way and recommend that. So again, you'll hear and see the identical language you're looking at in this agenda item 3A later when you hear about the civil rules amendments. It'll be helpful, I think, when you hear the presentation on the Rule 5 revisions to have all of this go into place, because there's a pretty comprehensive review of Civil Rule 5, and it's good. It takes and breaks down the modes of filing, the modes of service into the various kinds that are available, and speaks as to each one if there are special considerations. The beauty of this is that criminal defaults to Rule 5, family defaults to Rule 5. So if you see Rule 5, you'll see the bigger picture.
Great, appreciate that. No, any other questions? And I did notice that in the explanation in the reporter's notes, it did mention part of the rationale was for the day is a day, which warms my heart
Right.
because I
Are you a day as a day person, Martin?
Yes.
A day is a day. Many will remember those
Not a
days
working
as a
day.
days regarding these rules. Now,
Yes.
I did have just one last point of information, if the committee will bear with me. Members will recall the rule 11A4. And this is a rule regarding a type of pleading that a defendant can give in a criminal case, pleading guilty to an addiction to the underlying charges, predicate offenses, we call it. And I'm informed that at this point in time, the court is going to, perhaps next week, as soon as next week, promulgate as final that 11A4 rule. Remember, we have a conditional plea, which is 11A2. We added a plea 11A3, which requires a plea agreement and the consent of the state to preserve an objection. And then we are proposing an 11A4, which was actually suggested by Chair Lalonde and Senator Benning back in December. I think it's 2019. So we're getting there slowly, but we're there.
Yikes.
Excellent. Thank you
Yeah.
for the update.
Thank you. That's
Seems
all I
it's
have to
ages
say
ago.
about that.
All right, I appreciate that. So I really appreciate it, Judge Morris, and I guess we'll now be moving on to a couple rules regarding public access to court records. And Judge Thomas, did I probably mispronounced that? And Tomasi. I apologize. I apologize, Judge.
So are we going to lose John Treadwell without actually ever seeing him except briefly?
You are, unless there are questions that you have. Good to see everyone.
It's good to see you.
Thank you, Judge Treadwell.
Thank you.
Thank you.
I'm gonna hang on for an electronic filing amendment down the line in the civil package. Thank you.
Thank you. Thank you.
Okay, thank you very much. Judge Tomasi.
Tomasi.
Tomasi, I apologize. I messed it up twice. It's a good thing that I'm not practicing right now and in front of you. I'd probably be in trouble somehow, but
It's a good thing you've got the two of us with you today.
yeah, it's a good thing. It's a good thing. Yes, we're moving on to Rule 5C, and it's under 4A in the agenda.
Have we lost him?
No, I think I'm still here. Can you hear me okay?
Yeah.
There,
Yes,
yep, there we go.
There you are. Hi.
I apologize. I was actually going to make a foray down to the pavilion, but I got an emergency I'm still working on, so I couldn't cut myself away. But
Well, appreciate you here.
We're missing you, but it's nice to have you electronically.
there you go. So we're circling back on some rules that I was here back in November discussing with, I think, more of you back then. I don't know. And we had some discussions about various aspects of those rules that we made some changes. I think Chairman Lalonde was the one who had a couple questions about the scope of who could make a request for documents to be unredacted or redacted, and whether it only had to be parties or whether it could be people who received notice. And while it wasn't expressly in there, we thought upon looking at it a little more closely that he may well have had a good point, and that if you read it certain ways, it could be limiting. So we went back to the drawing board and sort of changed it around a little bit to make it clear that it didn't have to be people who had received notice. It could be a media organization. It could be anybody, non-party or a party, can make the request. So we kind of took that to heart, and we changed that around. Made a couple of other fairly small changes from where we were last November. One thing we did do is the Supreme Court wanted us to address what would happen for documents on appeal, because we didn't have anything in there expressly about that. And so we inserted a portion basically saying that in the normal course, the documents would have the same status they would have at the trial level. So if the trial court had sealed them, they'd stay sealed until something happened on appeal, and vice versa. And then there was also a new section about how you would go about making a request for to seal or redact at the Supreme Court. And we thought that the Supreme Court was on board with the idea that that would sort of be like a regular motion in the Supreme Court, which usually would go to a single justice, but potentially could get kicked to the full panel. So we made those changes, we added that, and it was promulgated, and I think it became effective. Those changes, the ones we discussed last November with you, as modified and tweaked a little bit, became final on 4/11, I believe. So those are now in force.
Wow, just this week.
Yeah.
Great. I definitely appreciate the additions, the changes to this relevant to what I asked about last fall. I did have one just really basic question. It seems that it's as far as notice to non-parties and the media and such, that's mainly through, at least initially, it has to do with how it's docketed. And I assume that's these motions are always publicly docket, they're in the docket, and it's pretty obvious that it's a motion to seal. And I'm assuming that that's the correct, but I just want to confirm that with you.
Right. That would be, it wouldn't give you much specific details, but it would be logged as a motion to seal. And then the judge, if the judge is granting a temporary seal or anything along those lines, there could be something more substantive, or it could be something just saying this will be heard on this date and time. The request will be heard on this date and time.
Okay, I appreciate that. Thank you. Any other questions on this particular, on these, it's more than one, on these three
The three,
rules?
yeah.
I think we're good. Thank you very much with that one. And we're moving on to Rule 6B, unless you had something more to say, unless I jumped ahead too fast on you.
No, I was pretty much covering all of those ones that were part of that package. So all my comments really were covering 6B, 20, 21, and 22, 5C and D, and 9.
Okay.
And
Okay.
9. But I'm happy to answer any other questions about them. We didn't make many changes to the other, or maybe any changes to the other rules from when you saw them last.
Oh, good, yeah.
Yep, no, I think, any other questions on the,
Nope,
on 6B, 14? No, I think we're good with that one as well.
You know what, I wasn't sure where you were going with 6B. I should tell you, I thought you were talking about 6B, 20, 21, and 22.
Oh, yeah, I'm sorry.
6B 14 is different, so I was going to make a distinction between those two things.
Oh, thank you.
6B 14 is one that you guys have not seen yet. So that was something that we drafted after we had the last meeting with you folks, and it came from a request from court operations folks and maybe some other folks who were concerned about the fact that under current law, or the prior rule that we had, it just said that for juvenile victims of crime victims, that you would use their initials in any filings. It raised the question about when people get older, and sometimes criminal cases are old, and or the people become adults after the events, or sometimes they're not charged. The defendants aren't charged until well after they've become adults. So the question was, do you go by when they were allegedly harmed as children, or would you go by their present age? And the committee felt, after hearing and having taken some discussion about that the idea was really to protect the children as children, and even if though you might become an adult, will become an adult hopefully at some point, that you were really trying to protect what happened to you as a child as well. So the committee felt strongly that we should keep it focused on the age of the child when the events were happening in the criminal charges. So we put that out there for comment, and I think that comment period ended this week as well. We got no comments one way or the other, but we have not heard from you folks. If there's some concerns that you have about that approach, I'd be happy to take it back to the committee.
No concerns here. Thank you very much. So I think we're all set, Judge. Thank you very much for your time, and hopefully you can straighten out whatever other emergency that we took you away from.
All right. Thank you very much. Nice seeing everybody.
yeah, good to see you.
So is Judge Kilgore here?
Or Kinvin,
Or
Kinvin
is
may
it-
be reporting this
Or
one.
is it Kinvin? Yeah. Oh,
Kinvin
okay.
is.
I do see Kinvin.
Kinvin is here, although not apparently visible.
You're not visible to us, Kinvin.
Maybe that's a good thing.
No, it's never a good thing.
No, not at all. Not at all.
Anyway, there
There we
I had thought that Judge Kilgore would be here, and the stated time for this committee is 5:15. So
Moving
A
along.
little early.
Yeah, we're a little bit early.
Sadly, some of us, there's so much happening. There are too many meetings this afternoon, so I
Yeah.
sadly have to.
I just
Well,
tried
it's-
to reach out to him and see if he can join. He might be waiting for a few minutes for his time, but I just tried to reach out to him and see if he wants to join us.
Thank you.
I don't know if you want to go ahead, Kinvin, or wait.
well, I could
We could-
start with the simplest item, I guess, which is the second one on our agenda, because Rule 66 was one that Jeff largely participated in the drafting of. And let me.
Oh, this is very timely for those of us who've just had parents die. Yes, indeed.
Which one, Rule 18?
Rule 66, inventory of trust accounts.
Oh, yes.
We're jumping ahead.
Well,
Oh, I thought you said 66. I'm focused on Route 66 too. It's like, oh.
yeah. Well, I'm looking at Rule 18D, which.
Oh, 18D, that's a different route altogether.
Right. Well, anyway, that should not occupy a great deal of time and might sort of allow us to vamp till ready as we await Jeff. Anyway, Rule 18. Rule 18D is a cleanup bit. The provisions of Rule 18D had really been altered by a series of other amendments concerning representation by guardians ad litem. And so, though perhaps a little late in the game, we have proposed that it be abrogated. And
is this out for comment, or have there been any comments?
No comments that have come to me. The comments do sometimes go to the chair.
I do believe that Judge Kilgore is now on, so.
All right, well, are you there, Jeff?
Do you want to yield to Judge Kilgore?
Or should we finish this?
Well, no,
I
think that was my question to Judge.
The question was, Jeff, whether there had been any. We began with 18D as a way of vamping till you showed up on time. And I said that I believed there were no comments on it in response to a question, but unless
excuse me. There were no comments that were received on Rule 18D.
Right, okay.
Okay.
Yeah, any questions on Rule 18B? I don't see any questions on that one, so we can jump back to Rule 66.
All right.
And depending on what section of Route 66 you're on, it'll depend on the speed with which we can drive down.
All right, Judge Kilgore. We're on Rule 66. I'd love to hear about that one.
In general, I would say Rule 66 was changed for the following reasons. We felt that a rule on inventories and accounting needed more detail than was set forth in the previous rule. And part of the reason for that was an attempt to make uniform what either counsel was already providing, what various courts were requiring in order to protect fiduciaries and beneficiaries to get more accurate information, more detailed information, which would give us a better idea as to the value of the assets that were being accounted for, and to create to create the possibility, to create a process rather for an independent review of certain accounts in either larger, more complicated estates or a method so that the court could order accounting where sometimes in complicated estates, either counsel or unrepresented litigants have a very difficult time providing the detailed information that's necessary to give the court a clear picture that everything had been accounted for. There seems to be a bit of an increase in fiduciaries not accounting properly, and the court, without the changes of the rule, some judges felt that they were pretty limited as to what they could do in an attempt to find out what was really happening in an estate or a guardianship, and to a lesser extent in trust accounts.
So I had a couple questions. So with, and it both has to do with subsection 1D, the inventory including firearms. But I guess one question is this a document, this inventory, is it a public document or is it not open to the public? I mean, if it's just...
It is open to the public.
It is.
All right, so I would say that I would, from my experience with firearms bills and such, that having an inventory of this detail of firearms can be very problematic for certain individuals. So let me just flag that for you. But then also I just was wondering why specifically that particular asset of having that additional information, why not jewelry, antiques,
weird, paintings,
yeah,
art,
hey,
much more valuable.
All the things that I was thinking of when I first read this. So, so there were the two issues that I kind of have with that particular provision. It seems too narrow, and it also will raise issues certainly with folks who are firearms owners of having a list of their firearms in a public document.
Right. And there are things of greater value that are not mentioned, particularly for complicated estates.
With respect to firearms has been an issue in a number of courts because many beneficiaries have found out after the fact that they were grossly undervalued, creating issues with respect to distributions. I think firearms had been, that issue had come up with firearms. To my knowledge, it had not come up with respect to paintings, jewelry, antiques, and those items. And so we were attempting to address those items for which we heard issues.
Senator Clarkson has a question.
So Jeff, why not just have all real property appraised? And then you'd have an appraisal on everything, whether it was an incredibly valuable piece of art or an incredibly valuable firearm. I mean, all you need to do is require that items that are listed be appraised.
There was, I believe, a little bit of confusion about that when the rules were circulated for comment. And there were a number of comments that felt that having appraisals was almost more invasive than actually listing the items.
Well, not if you have them insured. You have to have them appraised. So, I mean, if they're that valuable, they're probably insured.
And I don't disagree with you. I think we just felt that the existing rule with respect to having executors value property worked except for firearms.
Only in Vermont.
So I guess I'd like, Representative Byrd, because we've dealt with this issue before as far as inventories of firearms, if you have anything to weigh in on that.
just a quick comment as I would, whether I agree with inventorying firearms or not, which I think a couple people may know that I don't. I think we would be opening a Pandora's box.
Even if they were appraised, Tom? I mean, wouldn't it be simple to have things appraised?
Sounds simple, but
Why
yeah,
is that?
I mean, I just know how the the pro firearms advocates think and what they believe, and to be honest, I'm on the same level in a lot of ways with them, and I think it's going to be a fight we don't want to fight.
But we're talking about estate, so you're talking about passing down value to people and equity in estates and in distribution. So it's not about how people feel about things, it's about value and equity. So I have just gone through this with both my parents having died in the last 4 years, and I'll tell you, equity is as important as anything that might have a feeling around a firearm. Descendants care about equity, and until you have something appraised, it is not able to be equitably divided.
No, and I can appreciate that. But the thing is, when it comes to firearms, if you're getting a value on a TV set, there's not a multi-million-dollar advocacy group that's gonna fight against that.
Yes, but it's more likely to have a multi-million-dollar piece of art that needs to be appraised equitably so that you figure out if somebody's going to inherit it or it's going to go to auction. Same with a firearm. If you have a firearm that's worth $5,000 or one that is worth $25,000, I can guarantee you that those descendants will want to have that discussion about whether it goes to auction, whether it is a piece of the estate that sways, a distribution. I mean, this is for an estate and for a division. And I think equity is incredibly important here.
So I think that's true. And I think, but these are two different issues. The issue is whether one needs to have this detailed inventory of firearms. I mean, obviously it's an important asset and it should be appraised, but is there a different way rather than having such an inventory that would be a public document? I guess that's the question we're throwing back at you, Judge Kilgore. And that's the concern that we've raised. We're not in a position to raise any kind of official objection right now because we don't have a quorum. But I think that probably fairly lays out our concern on that particular issue.
Yeah. Well, estate. It's an estate issue.
In an attempt to respond to that, would it, given the members of the committee that are present, would it seem less invasive if we set out what I believe Senator Clarkson was talking about and requested that we make a laundry list of all items and all items needed to be itemized and appraised? Or
I think
items over a given value?
I think items over a certain value that need to be appraised. So, you could choose a value of like $5,000 because estates range all over the place. But a $5,000 item of value is of high value to many. But I mean, you could choose. I mean, you guys are all trust and estates people, so you know what
Yeah, I would think, that somewhat addresses the issue of the public inventory, detailed inventory of firearms. There may be some that are on such a list, but it's not like here's a list of the 50 firearms, because a lot of them are not going to be presumably of the high value. I'm probably speculating completely on this, but those are the two issues that we're trying to address. So, yeah.
And Jeff, I'd like to ask, why is this list public? Why is it any public person's business what is in a private estate? I mean, I've just gone through this. I don't think any of our documents through probate were public.
It's my understanding, based on the access to court records, that these have never been designated as either confidential or private, however you want to call them.
Really? God, I'm stunned by that. Do you think half the people that have just settled the states think that's all public information? I don't.
I don't know. That might be a bigger issue.
I think that's an issue we should discuss.
Not
maybe right now,
but discuss that issue.
Wow, interesting question.
I'll leave that for you to figure out with the bill next biennium, so.
Yeah.
All right.
Certainly the comment that you just raised, Senator Clarkson, goes to some of the comments that we had. I think we had 15 comments on this bill, and that's the most comments on a rule since I've been chair of the committee.
Yeah, I bet.
A lot of comments went to the fact that, well, aren't you giving someone a roadmap to access to someone else's firearms if they so choose? And I think there was not only comment but dialogue in these comments, and some of the dialogue was, well, you know, these are public records.
Well, if they're public records, I mean, I don't care about firearms. I don't own them. I don't value them. But I mean, artwork, which is like super valuable, or jewelry, if that's all detailed and public, that's ripe for burglary. I mean, then you have descendants. It's clear who they're going to. That's just, to me, I mean, and firearms, obviously, if those are a value, you're not going to steal a mobile home. But I think that's a big issue, is having all of this public and in such detail, and then you know where it's going.
Right.
I think that's a big subject.
I think a lot of people would be very pleased if these were not public records.
I would second that.
So, but is this an issue really for the Rules Committee, or is this a legislative issue?
I don't know, but we've just identified it as an issue.
It is an issue, yeah. Do you have a viewpoint of that, Judge Kildor, of where such an issue should be fully resolved?
I think that's an issue that needs to be resolved at your level.
Right, okay. All right, appreciate that.
Thank you.
You're welcome.
So are you putting in the bill request to Eric right now for next?
Eric, did you just hear that? Oh my God.
I did hear that.
We all have to get reelected first.
Well, that's true. But all right. Well, I appreciate that. Anything more on that particular bill, Judge Kilgore, or anybody else here at the table, or Tom? Eric.
Yeah, just one clarification, Representative Lalonde, that you had mentioned during this discussion back and forth that you didn't have a quorum and therefore wouldn't be able to object. But I just wanted to remind the committee that this is only proposed. So you wouldn't be objecting anyway. So all the comments that you made are comments, and as they should be. So as Judge Kilgore noted, they can take them into account as they go forward, and assuming at some point you'll see another version of the rule after it's promulgated.
Okay, great. Thank you for the reminder, Eric.
Yeah.
So sorry, I'm just confused because they're proposed, but the comments were due back December 15th. So I just assumed that we're moving right along here on these.
Well, they haven't been promulgated yet, so they can take comments into account, even though the formal comment period has ended. Any comments that you make, and this is your first look at these rules, and it is true that sometimes when we're not able to schedule things soon enough, there are times when rules get promulgated without the committee having seen them. But we make an effort as much as we can within the schedule so that you have an opportunity before they're promulgated to make these comments, and then so there still is time for the court
I'd also think we should recall that the Rules Committee itself, in reacting to the comments that have come from the public or through this committee, sometimes comes up with comments of its own that result in changes that haven't yet been.
Oh, we like that. We like that. So Jeff, may I ask you another question? And maybe Ken and you both have an answer. When on this kind of a rule, well, on all rules, do we reach out to lawyers who practice in our courts but are not, who may be New Hampshire based? I mean, obviously, if they practice in our courts, they also have a license to practice here. But so we reach out to all of that crowd, right?
Well, the judiciary's public circulation of proposed rules goes to, I don't know exactly what the list is, but maybe Emily could.
No, I assume, Emily, it would go to all lawyers who practice in probate court here in Vermont.
Under Administrative Order 11, all of the proposed rules get sent out to all members of the Vermont Bar. So if you are living in Florida, but you are a member of the Vermont Bar, you would receive the information about any of the proposed rules.
Got it.
So it's not really about where you physically are located. It's about whether you're a member of the Vermont Bar.
Yeah.
Thanks. Thank you.
And I would also point out that the chair of the Bar Association Probate and Trust Committee is on the committee, and he put out a separate request for comment to the Probate and Trust Council's listserv at the Bar Association.
Which perhaps accounts for the quite large number of comments that we received.
Right, got it.
It did.
Are you good, Al?
Yep.
I think we're all set. Thank you very much, Judge Kilgore and Kinvin. Really appreciate it.
Thank you.
You're welcome.
And do we have, is Alan Keyes on yet? Have we seen him show up?
So there's somebody in the waiting room that I can't identify, and I've asked them to rename themselves or email me with their name, but it's just 4 letters, and
What's the 4 letters?
Yeah, they made
ZPHX.
I'm not sure where we get Alan Keyes out of that.
Yeah, for security, can't really let them in until I can identify them.
Well, it's only 5:29, so he's not late yet.
Well, he's usually here minutes early. So, so Emily, are you reaching out to Alan just to see if that's him?
Yeah, sure. I can try to reach him right now and see if he's trying to get in or if he's on his way. Just a minute.
I appreciate it. Thank you. We're right on time. Have you noticed that?
Yeah, impressive.
very well run.
Well, I was hoping to be 15 minutes early.
I've got to sadly go, so.
Yeah, I know. I thank you for being here, though.
No, I'm sorry so few of us are here.
It's that time of year. But I thought it was important to get this moving along.
Okay, it is him.
Okay, great.
Yeah, no problem.
Who are we waiting for?
Alan.
I'm just sending this off to my company.
Okay.
I think we're
Did you get it, Mike?
Yeah, I got it.
Okay, great. Thank you.
Thank you, Emily. Hello, Alan.
Yeah, sorry about that. That's my anonymous screen name that I post tweets with, and my computer somehow just called me that instead of by my real name.
Well, now we know your anonymous name, so you're not so anonymous
Yeah, exactly.
anymore. You might have to change that.
You're welcome to look at my tweets. I tweet every day from the Journal of Henry Thoreau.
Oh, awesome.
What a great idea.
Awesome. If I did Twitter, I would look, but I've managed to stay out of that even though I'm a politician. So Alan, I appreciate it. We're moving on, and I like the COVID beard. Looks great. But we're moving on to the rules from the I guess they're the civil and probate rules, and starting with the Rule 3.1, 4, and 84. Unless that's you, Kenvin. I don't need to punt that over to Alan if they're reporting on that.
I'm happy to have you punt it over to Alan.
All right, it's all you, Alan.
Well, just to set the scene here, this is a group of rules that really center around some changes within the court administration regarding the compilation and publication of forms. The rules in their original adoption many years ago were in the source of rules of forms, as it were, but the evolving role of the court administration with forms has really rendered the group of rules that are dealt with in this order more or less obsolete.
Yep. So this is, you're talking on which one, the, just to make sure.
Well, it's item 8A on the agenda. And
Right. Oh, and are you speaking to Rule 84 or the Rule 3.1?
Well, Rule 3.1 primarily. I've now got this.
I mean, I think 3.1 is pretty straightforward. I think
I'm happy to cover 3.1 if you want. That's the small amendment to the rule about waiver of filing fees and service costs.
That would be great, Emily. Thank you.
Sure. Just for the record, Emily Wetherell, I'm the deputy clerk at the Supreme Court. There was a pretty big overhaul of this rule not too long ago, maybe about a year ago. And as the rule was being implemented, it was clear that there was a small change to the rule that was necessary that maybe was just overlooked when it was amended before. So part of the prior amendments was to make sure that when we're assessing whether someone is indigent and can waive the filing fee because of that indigency, it's not the household income that is looked at, it's the income of that individual. So that's that minor amendment that you're seeing there to take out the word household and just replace it with the applicant's income. And that's consistent with the rest of the language in the rule.
Great, thank you. I don't see anybody with questions, so no, that one seems quite straightforward. Appreciate that.
And then the rest of them can be in that package 4 and 84 are about the abrogation of the forms.
Right.
I'm not even sure if people realize that the forms were still actually living in the actual rules. And as Kenvin mentioned, the court administrator has been hosting those forms on the judiciary website, and it has been pretty clunky to amend a form by going through this whole formal process of amending rules in order to get a form changed. And so instead of having those forms live within the rules themselves, this is just moving on to saying that the forms will be on the judiciary website as approved by the court administrator. And that's been true now for probate for some time and for family. So civil's just sort of following along in that.
Yep, great. No, I don't recall that we had any comments on that when we looked at it proposed. That seemed straight.
And did we lose Alan again?
We did.
We did, okay.
Alan's having some connectivity problems.
There are forms that actually are laws with some rules, and so they kind of skate outside this amendment, I guess we could say.
But those aren't in front of us at this time, though, I take it.
Right.
Okay.
So Rule 56, I would say, is here more as a matter of rule presentation convenience. Emily, you might agree
He's back up.
with that. The rule came through the committee at about the same time, and it's essentially an effort to standardize and make clearer to follow the procedure for a summary judgment motion, which is an important engine of increasing the resolution of civil actions short of trial. So
a question on the Rule 56. I know we took that up and looked at it closely last time. Were there any changes relevant to when we saw this as a proposed rule?
Well,
Kinvin?
I guess it's still a proposed.
Is it still? Well, I don't have it down as proposed, but.
This is Alan Keyes again. Can you hear me?
Yes, we do have you though.
Yeah, my recollection is one of the questions you asked at the last go round was whether the format requirement of separate paragraphs for each fact and the responding party respond by paragraph number applied toward the end of the proceeding when we had replies and surreplies. And the answer is yes, we did change that, and there's a sentence in there that says all those papers have to comply to that, what I call call and response format.
Yeah, I didn't have any other questions on that particular rule. I don't see any questions here, and I don't see Tom Burnett. So we can move on from that one. That looks great. Appreciate that. Input was a tag team. Emily, Kinvin, and Alan handled that one. So moving on to the next one is the Rule 11E, Vermont Rules of Civil Procedure. Who's taking that? Is that over to you, Alan?
I guess so, yeah. During the pandemic, we were confronted with the problem, you can't be personally in the presence of anybody, including notaries. And we were asked, what can we do about that? And the answer was not to change the rules about notaries. Those have been done, I understand, on an emergency basis by the Secretary of State, and there's legislation pending. But what we did was adopt a declaration rule that says you don't have to have a notary in certain circumstances. And so this uses declaration language that was found already in the statutes. And the second and third paragraph clarify the meaning that I just said, you don't need a notary. And then the major decision we made was to make this apply only to oaths otherwise required by rule. We did not extend it to oaths required by statute. We had the subcommittee try to inventory all the statutes that were requiring oaths that were modeled into the rules. And we tried to decide, or thought about deciding, whether the personal presence and the solemnity of the occasion was so important that we should not substitute a declaration because the legislature had said an oath is required. And instead we said, let's let the legislature decide that. And so this applies only to oaths or affidavits required by rule.
So I guess I have a question on that, and I do recall this now. Is that a list that you have or that the committee has that can be forwarded to us so we can take a look ourselves and see if we should change it in statute?
I can contact the subcommittee person who worked on that, and I think she has probably got good recollection, although I think she may be away on vacation during this week that's coming up, but I can
There's no hurry. There's no hurry. That wouldn't be till next biennium anyway. But I don't want to lose that helpful information. And actually, if you could have that sent to Eric Fitzpatrick, and he can kind of hold on to it for us, that would be great.
So it's not just the pandemic, but the ability to use a declaration is just very useful. It's in federal practice, and what comments received were positive and said this is helpful generally. So we made it a permanent rule. Right.
No, appreciate that. That makes a lot of sense. I think it's great.
What this required was the court administrator to assemble a team of experts to go through all the forms where an affidavit was required and substitute the declaration or make it an option. And it shows the interplay between we make a rule and it's fine, but it creates a lot of work for the court administrator when now it's their responsibility to do that. But it worked out. The forms were changed in time, and now they're in place.
Excellent. Well, thank you. Well, that's great.
Could I add to that just really briefly?
Please.
That there is an existing statute that allows it's for VSA 27B, and it allows those who are filing electronically to substitute a declaration for a notarization. So if you are an attorney and you're filing through the e-filing system, you can use that declaration in place of a notary. And, I think we feel really strongly that it's even more burdensome on the self-represented litigant to be able to find a notary and get a notary to use. And so I think in the judiciary, the miscellaneous bill, there was a recommendation to amend that statute so that the declaration in place of the notary could be used both by e-filers and by non-e-filers. And then we wouldn't have this situation that we have now where the rule only applies to those requirements that are in rule versus those that are in statute. But there is a little bit of inequity at the moment because people that are attorneys and are filing through e-filing, they get the benefit of that statute where they can use the declaration in place of the notary, but primarily self-represented litigants who are not electronic filing don't have that general exemption.
Right. I'm trying to recall if that, I seem to recall getting that request, but we were unable to put it into the miscellaneous judiciary bill.
I'm not sure if it made it in, but I would urge if possible in the future to get that so that we could have uniformity both for e-filers and non-e-filers.
Do you know who, was it you that reached out or did somebody reach out to, I'm trying to see who reached out to who with that recommendation.
I think it might have come through Judge Zone.
All right.
If we could get if we could find the language. Eric, do you have the language or?
No, I don't recall seeing it, and I just pulled up the bill. It's not in the miscellaneous bill now. No. I don't recall seeing a request for it. That doesn't mean I didn't see it. Just my memory, as I currently remember it, is not pulling it up. But I did get other things from Judge Zone that are in there, but I don't recall seeing that one.
All right.
Okay. Thanks, Eric.
Sure.
Well, it's probably not too late to do that either if it's straightforward.
Yeah, we might be able to do it. Yeah.
Do you want me to follow up on that or?
Yeah, I'm seeing, okay, here we go. I have the language. I think this is, all right. Yeah, yeah.
We'll take a look.
Senator Sears and see if, I think this is it.
Yeah, if you could forward it to me as well.
Sure.
I can see what it,
Thank you for indulging me on that. I appreciate it.
Yeah.
No, it's important. Okay. So yeah, we'll take a look at that and that makes a lot of sense. So moving on though to Vermont Rule Civil Procedure 43E and 54D are both, I believe, in the next one to take a look at. And I assume that's Alan as well.
Yeah, this is, well, as you say, correcting and updating a cross-reference. So we consolidated Rule 78 and 7 into Rule 7 and did not check thoroughly that there were cross-references to Rule 78 existing in the rules, and this just changes 78 to 7 in those.
So it's a technical change is what it looks like, yeah. All right, that one's pretty straightforward. So Rule 50B is a proposed rule.
Yeah, there's a sentence right in the middle of Rule 54B that says renewal of a motion.
50B.
50B, I'm sorry.
50B, yeah, sorry.
Renewal of the motion is necessary to appeal from a denial of or a failure to grant a motion for judgment as a matter of law. And in context, the motion refers to a post-judgment motion. So you make this motion at the close of the evidence, plaintiff's evidence, you make it at the close of all the evidence. And this rule authorizes a post-judgment motion. This sentence is not in the federal rule, and it was added in 1988 because people weren't reading the precedent. The federal precedent says you've got to make this third motion. And so we thought it would be helpful to people to have it in the rule that you've got to make the motion. And fast forward 30 years or more, and the court has a case where the party did not make the motion, but the federal precedent has departed from what it was in 1988 and says, well, some of the time it's not necessary to make the motion, and variously characterized where it's not a question of the sufficiency of the evidence or where it's a pure question of law, something like that, where they have decided that in the interest of justice, basically, we don't need any additional record or any additional motion in this context.
As the material points out with the rule, the court had a concern about this issue that, in a way that was non-dispositive of the particular case, but they asked the Rules Committee to look into it. The federal evolution that Alan mentioned is kind of happening in a variety of ways around the country, in different ways in which federal circuit courts of appeal have dealt with the efforts of judges to get to the heart of the matter in these cases. And so we're trying to, in effect, keep up with the direction of the federal interpretations of the otherwise very similar rule, I mean.
What the court said in this case is, well, I think I may be mischaracterizing it, but they said, we recognize that some cases the federal courts have allowed it, but even if we wanted to, the rule says you can't. What we started out as a rule as a guidance for practitioners became a rule that said the court can't decide a case that it wants to, because the rule says it has to be made, despite the evolving precedent. So there are a lot of options. The committee decided to add to the sentence the qualification, the motion that raises the question of sufficiency of the evidence. An alternative was to say that a motion to make an exception, except where it's raised as a pure question of law. And indeed, we got a comment after publishing this that someone said it would be clearer if you said except if it raises a clear question of law. So it went back to the committee, what should we say? And we've recommended some changes to this language, which basically are a point of emphasis to the way we phrased it. It has to be a question of the sufficiency of the evidence. The appeal must be on that issue. And we changed where it says the motion, the article "the," we changed it to a reference to say a motion under Rule 50A that based on the sufficiency of the evidence. But the change we recommended doesn't change the
Meaning, right.
wording choice we made.
All right,
And
well, I think this one is, well, it wasn't straightforward because I had to read it once last night, but it was getting late and maybe the martini was involved. And, but I reread it this morning and it made sense. So I think I'm good with this. Any questions? So I think we're good with that one, unless there was anything else on that. We'll move to Rule 55 and 62.
These have not yet, I believe, been reviewed by the committee. They were, this actually group of several rules were.
So Kenvin, we can't hear you very well. I think you're speaking away from the microphone.
Yes, I'm sorry. The committee's not reviewed this, and the next group of rules, I guess, was all I was trying to remind us.
This rule is still in proposed state. We've had comments on it from a few comments similar from creditors who say it's, we've already gone to the trouble sometimes of getting personal service. It may be difficult, it's expensive. Do you really want to add to the expense to us and ultimately to the debtor of additional service? What the rule is saying, as I understand it, is you can use certified mail, not regular mail. But and then they're saying secondarily, if we're going to have additional costs, we should be able to recover them. And what is the procedure for recovering, putting costs into a judgment after the judgment is entered and already includes costs? And the committee thought that second objection have enough merit that I've appointed a subcommittee to look into that and come back with perhaps a proposal. Rule 80.1 already has some provisions for collecting, cost of sale that occur after a judgment, but we might need a more generalized rule about costs that are occurring after judgment, how you put those in. One suggestion was, well, the judge should estimate the cost. So I've got a subcommittee responding to the creditor's objection that there's no procedure for post-judgment recovery of post-judgment cost.
So this rule is going to be changing based on that input, presumably.
I think so. Yeah. If I can predict, I think they will come up with a proposal to specify how post-judgment costs of service are included in the judgment. Otherwise, it's that we are not headed in any direction of other than requiring service of the judgment. It's already required prior to in Rule 62 before you execute, but this is driven by other procedures that are more often used in small claims than otherwise. The financial disclosure, the judges are and people involved in these cases are concerned about defaulting defendants not really knowing what's going on. And so we want to give them another chance to come in and respond to the default.
So is there any notice obligation to default? I mean, what's the notice obligation under current law for those who obtain a default judgment?
The Rule 62 says you can't execute on a default judgment unless it's been served.
Okay.
But this is going to expand on that. Say you once it's entered, you must serve it.
Right. Okay. All right. I got the difference now. Thank you. Any questions on this one? I think we're good with that one as well. So moving on to Rule 68.
When the civil trials were essentially suspended, it was suggested maybe we can help the situation out. Plaintiffs are waiting for their trials, and naturally defendants say there's no need for me to settle the case because no trial is imminent. So we had a suggestion maybe we could make Rule 68 reciprocal, that not only a defendant but a plaintiff can make an offer of judgment with some consequences if the it's refused and the person who made the offer does better. We solicited the input of defense lawyers and plaintiffs lawyers, and particularly the plaintiffs association. You know, some would have wanted interest and other things other than costs, attorney's fees added, but it raised too many questions, and we've just it just refers to costs, which in the case, except in special cases, say a civil rights action under federal civil rights action, it does not include attorney's fees. So it's some modicum of equalizing things. And so it was in AO 49. We decided to propose it, that it be permanent. And we've received no other comment on it other than, actually there was one comment in support saying it's a good idea. So on this one on Rule 68, there's something awry in the second sentence. I looked at the current rule, and rather than trying to explain, if you could kind of double check that language that's in the second sentence, if within 14 days after the service notice that the offer is accepted, if you could just double check that.
That's the existing language, but that doesn't mean we can't clarify it.
Is that well? I guess I looked it up because it didn't make sense, and I looked at on the rules on Lexis, I think it was, and that sentence was different there. So
it's supposed to be
unless I was looking at the wrong rule, but I don't think I was.
Anyway, we'll certainly follow it up.
Yeah. But other than that, I thought that made sense. No other questions or comments over here.
Thank you for that. It's always helpful to get a fresh reading of these things, and we appreciate it.
A fresh eye.
Well, we'll see if I was right about that, but I think so. So on to Rule 7. I'm not missing one. Am I? No, that's right. Yeah. Rule 7, 8.
Small claims rules.
Yeah. Let's see. These address, among other things, the contempt issue that came up with an assistant judge a little while ago who was putting people in jail for not paying judgments. And so it clarifies how to deal with contempt, if my memory is right. But it also is part of that trend of giving the debtor a little more notice of what's going on. And we received, if I'm remembering this right, we received a couple of comments from the ACLU and Legal Aid about improving this by requiring service of the financial disclosure form and some other papers that would be of importance. And as we've voted to recommend this to the court with those changes, if I can find my notes, I can tell you more specifically what they are.
I suppose another point is that the suggestions for change originated in the court's Civil Division Oversight Committee. We do have a certain amount of back and forth with that committee. They come up with ideas and ask us to consider them as rules, specifically as rules amendments.
I have it now before me. We were asked and agreed to change proposed Rule 8A to make the contempt hearing discretionary, the way it was.
Okay, yeah, that was what I was going to ask a question about that it seemed, I was even wondering, well, let me ask you this way. Actually, if it's discretionary, then the court's still deciding, would it be discretionary even if the judgment creditor has filed a motion for the civil contempt? I guess my question initially was, why are we relieving the responsibility from the creditor for filing that? I think I understood from the notes that the reason was to make this more efficient somehow, because the process is drawn out and inefficient, but still putting that obligation then on the court to schedule a contempt hearing as opposed to it being prompted by the creditor's motion. I mean, that seemed a little problematic, at least to me. But maybe, so how would the discretion, I mean, how would it work as far as the court would have discretion on scheduling the contempt hearing?
I'm sorry, I don't have the language that we adopted in front of me, but I recall there was a must schedule or something like that, and it just seemed the judge should be able to take a look at it before the judge requires a contempt hearing.
Right.
We tinkered with it a bit. I'm not exact. I don't have it in front of me. Sorry. Maybe Kinvin does.
So.
And there was
I mean, I can understand the court having discretion if it's, if it's a civil contempt, it's certainly within the court's discretion. But presumably even if the court has discretion, if the court decides not to immediately order a contempt hearing, presumably the judgment creditor could still move for a contempt hearing. Is that right?
I would agree, yeah.
So maybe that's fine then.
I can be a little more precise. The second change to the proposal we made was in 8B2, and it makes it parallel with what Rule 7 already provides, that there be personal service of the form financial disclosure affidavit and the list of exemptions. I left out in my summary the list of exemptions.
Right.
So what these are usually about is not, the willful contumacious conduct. It's just the debtor doesn't know what's going on, and what they need to do is come in and say whether they have assets, so that the form is sent to them again.
Right. Which, I guess that's to me still that the creditor probably should be the one prompting that than the court, but. So I mean, that's just my comment on that. Do with that what you will, but. I do agree that I think it's right to not have the kind of shall language, or will, actually it says, the court will schedule. At least that certainly seems to be a move in the right direction. Any other comments or questions on that one, Maxine? So unless there's something else on that one, we can move on to Rule 5, 6, and 29 and 11C, the service and filing of pleadings and other papers.
Okay. This is a big one.
Yeah.
This involves email filing and email service. And we had a few false starts with it, and we've made some fairly substantial changes to the proposed rule. But there are 2 or 3 things, sort of a roadmap is and I think you mentioned the last time we were here, is remember this is for pro se's, to make sure pro se's can deal with it. So we have, the rule is basically divided into how to get service between attorneys, and then how to get service when there's a pro se involved. If you skip way ahead in the packet to Rule 79, which is the notice of appearance, we've changed that, but that shows our approach to how to deal with the pro se in email service. There's an existing form that is required for when you file a lawsuit when you're pro se to be filed. And it says very clearly, the court has to keep track of you, give us your name and address, provide us notice when those changes. It's the notice of appearance form for self-represented litigants. And what our insight was, have the court administrator change that form, put it into plain language to say, give us your email address. And if you want to be served by email, check this box or indicate. I presume the court administrator will have a box. So a self-represented litigant who checks that box can be served at the address they provide on the notice of appearance form. And that form, as I say, is the court staff, or it's on the website. You have to use it when you start an action. When you serve the complaint, you have to serve the blank form to the other side. So the self-represented litigants get that form, and on that one form, it'll tell them if you want to receive emails, or give your email address, but if you want to be served, check this box. And that's the way email service will go. Yep. If you hold that thought, we had in the proposed rule an artifact of the old rule, something called service by delivery to the clerk. When everything else fails, you just you can't find the person, you give it to the clerk. And we really questioned whether we should keep that or not, but we didn't take it out of the proposal. And ultimately that became a factor in this email service on, using email to serve a pro se litigant. What if the address they give, they move and they're no longer there, they no longer live there, there's no mailing address. They either haven't checked the box or they have checked the box and it comes back, that's not a good email. What you don't have in front of you, but what we have recommended to the court is that there be another method of service on a self-represented litigant in last resort, instead of leaving it with the clerk, is serving it at any known email address that's listed on a pleading or a filing with the court. So if we have some email address, although they said I'm not agreeing to service, as a last resort, it'll be there. And then lastly, there's the rule that you don't have, will have the third method of email service on pro se litigants, which is the existing rule by agreement. So the rule says there are three ways. You can have a checkbox, you can agree with the other party, or if you don't have an address and we can't reach you otherwise, we'll use an email on your, it's on a filing. But we are limiting the delivery to the clerk as a method of service to cases that would arise under the abuse and prevention rules, where the party gives an address, but it's by rule or court order confidential. So the clerk knows where the person lives, but the other party is in the dark as to where they are. If they can't provide service and certify that they can't, it can be left with the clerk, and then the clerk will serve it. So there's a lot of little, those are details important that we've in the process between proposing this and promulgating it, we've worked out.
I'd like to add that the Probate Rules Committee has been working on a version of Probate Rule 5 that pretty much follows what Alan has described, but has certain variations that committee will deal with at a meeting next week. Emily, can you comment on where the court has been on these things? The court did discuss the matter, I think, in a recent administrative meeting.
Yeah, I guess I can say that the court is definitely supportive of the efforts that are being made. This was really done at the instigation of the court in AO 49 when the pandemic started. We put some provisions in there to allow for email filing and easier email service. That's where this started. And then the court did ask the rules committees to look at making that more permanent. it certainly has been really helpful to both court staff and self-represented litigants to be able to serve and file using email. I think the court also wants to make sure that there's continuity throughout all of the divisions so that we're not having different rules that apply for filings that are going to the family division versus the civil division versus probate. So it's, I think, taken maybe a little bit longer than we had hoped, but the Rule 5 that Ellen was describing and Judge Morris alluded to earlier in the meeting, that rule is incorporated into the family rules, into the environmental rules, and into the criminal rules. The appellate rule basically is being amended also. I think it's on your list here to incorporate
Yes.
Civil Rule 5. And then probate would be the last sort of piece in that puzzle. So, you know, I think the court is sort of waiting so it can get the full picture of all of those at the same time, but is definitely supportive and grateful for all of the work that's been done to, you know, get this package all together.
I take it the court would welcome a sense of how this committee, the LCJR, looks at least what it's able to glean from the draft that's now before it.
Absolutely. Yeah.
I mean, I certainly didn't find any issues with it. It made a lot of sense, and I think it's helpful for pro se as well. So I think this is great. I did
not to cut you off when you're saying good job, but there's the attorney service part. The way we solved that, we were attempted to find ways where the attorney would be registering addresses outside of the Odyssey system that would be used for email service. And we found the solution was, because most of that service outside of Odyssey was discovery, was to require discovery be served through Odyssey. And Odyssey has become the best practice. You get a good, you know that it's going to be served to the correct addresses and you have a record. So the only thing that's outside of Odyssey is the unique situation. So you have a ton of documents that can't fit in an email or can't fit in Odyssey. And those have to be case-by-case agreements. So that's how we...
Just real quick, I mean, is that a change from what I'm looking at here? I thought that it could be by agreement that the parties can agree not to do it through Odyssey. Is that something that's changing from this proposal?
It's difficult to remember when the change came, but I think the idea that to mandate that discovery be pushed through Odyssey was not in our original proposal that you're looking at.
Right, that's where you see 11.
It's
the
in
amendment of electronic rule 11C basically takes the existing rule, which said any filer may but is not required to serve discovery by the OFS system, and says any filer must serve discovery by the system, even though not required to be filed with the court, unless the parties have an alternative method of agreed to an alternative method of service. And all along 11D2 has provided this alternative avenue for people to opt out with respect to service. It's somewhat cumbersome, frankly, intentionally, to make sure people first go to Odyssey if they can do that. But that option is still there, Mr. Chair. An alternative agreement.
I think just the one point though, Judge Morris, is that for discovery, the amendment that Alan is discussing is that the default is that you're going to serve using, I want to say Odyssey file and serve, but you're not actually filing. You're just serving on the other side. And you can, you're right, Representative Lalonde, in there, you can agree to serve in another way. And when you do that, it's not as onerous as the general service requirement of something that you would be filing with the court. You don't need to submit your agreement with the court in order to do that. You can just agree amongst yourselves. It's just about service of discovery documents that, this is something that we're going to agree can be served through some other method, not using Odyssey file and serve. So it's not quite as onerous that way. It just requires an agreement between the parties to do that.
Yeah, thanks for that, Emily. That's correct. And in criminal rules, where the state's attorneys have a pretty high volume of discovery service going on, they've already gone to this, and it's preferred as the method to serve discovery in criminal cases. Initially, when you get your initial charging packet, you get discovery along with it. So that seemed to work well.
Right. Well, it makes sense. I mean, it makes sense to use the e-filing system as much as possible. So, all right, appreciate that. That makes some sense. Was there more on this particular rule that you needed to go over, any of the folks? This is more than tag team. We've got 4 folks on this one. This must be an important rule.
Well, I guess they're in rule 5. It's in my head, so I'll spill it out. The email filing, there was some tweaking of how an email filing is done to be very more clearer about the court address, and the reporter's note will contain a new reference to a new website where all the court addresses are listed. So the rule has been clarified a little bit there about where the filing goes. We had some comment about that. Then there's, what are all the other rules in the packet? Rule 29 is there because that involves this question of you must do discovery through Odyssey. Rule 6 is the time rule. So we've had the existing rules say electronic filing, you can do up to midnight. And this adds email to that. So if you email up to midnight, it's counted on that day when you're counting time.
Right.
And I've already mentioned rule 79.1 as kind of the, we've renamed that, you'll be happy to know, not pro se appearance, but appearance by self-represented party.
Yeah, perfect.
It's, if pro ses, we'll still call them pro ses, if they do read the rule, they're going to be ruling 79.1. And I think we've made it as plain language as lawyers can. But I'm confident that the court administrative staff who's responsible for writing the forms, who's not a lawyer, can maybe make it even clearer. And that's what the self-represented litigant will be guided by, is the website and the forms.
Great. All right, thank you. Thank you for that one. That looks great. So then we'll move on to Rule 25, the Vermont Rules of Appellate Procedure. I assume
You want me
this
to do this one, Ellen, or?
Sure.
I think that was your rule.
I mean, I think this will be actually pretty straightforward,
Yeah.
given the prior discussion. Basically, the appellate rule is now incorporating, the appellate rule always incorporated the Civil Rule 5 provision regarding service, but now it's also incorporating the Civil Rule 5 regarding filing. So all of those provisions that we were just talking about in Civil Rule 5 about email filing, email service, that's now basically the same for in the appellate court. So again, just trying to get some of that uniformity across all of the different divisions.
We like uniformity, so this looks good.
Yeah.
Especially when you're dealing with self-represented litigants.
Yes. No, that's very straightforward. Thank you. So Rule 26.
That is back on the Civil Rules Committee's agenda for next week with a drafting question. I don't know, Alan, do you think it might be better to defer that till next time?
Sure, we can, yeah, I mean, if this is going to be changing, sure, why not? But it's up to you.
It's when does the comment period expire on this? It's May 5th or something?
May 9th.
So, well, in June, I suppose, or late May, we'll be acting on this, and it may change again, but it's in response to a problem of an expert deposition being taken, and then the expert changes the opinion and it's not disclosed. So this updates this supplementation requirement primarily for that purpose in the paragraph 4 that you see, and it's consistent with federal law.
So it'd be also a mistake or a change or whatever in the deposition.
It's what supplement or correct is and what is the other language? If the deposition is incomplete or incorrect, not only when made, but because of subsequent information. So it's an updating of the supplementation rule to make it a little stronger. And we're going to have it, as Kim had said before, us again before we make a recommendation to the court.
No, I think that's straightforward. Appreciate that. Any question on that one? No. Moving on then to rolling just right along to Vermont Rule of Civil Procedure 80.6. Looks pretty straightforward. Looks to me like just a technical change.
Yeah, that's right.
Probably don't need to talk about that one then. We'll move right on to the last one and see if we actually, it looks like, we have 8 minutes and I thought I was going to get us out of here early, but it doesn't look like it. So last rule, 79.1E.
We got a request from the Civil Oversight Committee to clarify that when a motion for an out-of-state attorney to be admitted pro hac vici, the attorney should file some affidavits about their qualifications and their disciplinary record. And we ended up with a rule that's kind of just the opposite. A few years ago, all the rules and all the divisions about pro hac vici admissions were changed to make the process start with the court administrator, and those affidavits, what is specifically required about their out-of-state admission and their disciplinary record is submitted to the court administrator. The court administrator issues an admission card, takes a fee, and the lawyer is admitted for purposes of that case. And we thought instead of taking the suggestion, we would, and it was kind of based on the language of the rule that in the discretion, the court can admit if we're going to exercise discretion, we want to know more about it. And we responded by a rule that deletes the discretion requirement and making the admission as a matter of course if they've got the card. It requires, before it ever becomes permanent, the court would never allow us, the civil rules, to do this and not the other several rule sets that have identical rules. So it requires a lot more process before it becomes final. But that's the idea. If you think it's a bad idea, you better tell us, because the other committees are going to go forward with it.
I have no reason to think it's a bad idea.
So the judge under the draft must accept the pro hac vici appearance unless good cause exists and is found for not allowing it. So you'll be seeing a criminal amendment as well on our pro hac vici rule, and likely a civil amendment on pro hac vici rule too.
This is in that last, just recently sent out her comment package where the comment period is open till May 9th. So,
right. So we'll have another shot of looking at that one, and hopefully we'll have a few more people here in case we can smoke out some objections there. But the folks that you have here today don't have a problem with that one. Well, I really appreciate it. Yeah, I really appreciate your time on this. Thank you so very much. And we'll see you whenever the next time is.
Thank you so much for taking your time out of the busy schedules. I really appreciate it. I know the court really appreciates your input. So thank you both.